You have 8 minutes left. Does the defense wish to respond?
Yes, Your Honor.
You may proceed.
Ladies and gentlemen, this case is a case about unmet expectations. And before we get into the facts of today's case, I want to tell you a story. Hundreds of years ago, there was a king who was riding his white stallion through the forest. And as he rode, he saw all the trees of the forest. And in each tree, he saw a target with an arrow in the center. And the king said to himself, "This must be the greatest archer in the land. I must find this archer." So the king kept going through the forest. He asked all his men to help him find this archer. And eventually, they found the archer. And the king went up to the archer and he said, "Are you the man that's putting the arrows at the center of all of these targets?" And the archer said, "Yes, I am. That's me." And the king said, "You must show me how you do this. You are the greatest archer in the land." So the archer looked at a tree. He strung an arrow from his quiver. He strung his bow, and he fired an arrow into a tree. Then he walked over to the tree, picked up his paint, and painted a target around that arrow. Opposing counsel at opening today shot an arrow into a tree when he said that my client, Joe Pringle, is guilty. And he spent all day long trying to draw a target around that arrow. As I said, this is a case about unmet expectations. You, ladies and gentlemen, when you came to court today, you might have had some expectations of what you may have heard from the state, what the state would give you, because it's the state that has the burden of proof. You might have had the expectation that when the officer pulled over my client, Mr. Pringle, that he would have pulled him over for something. There was a sign of a DUI. You might have expected that Mr. Pringle would have been weaving in his lane, but you didn't hear that today. You might have expected that Mr. Pringle would have been swerving in the two other lanes. You didn't hear that today. You might have expected that Mr. Pringle might have been going well below the speed limit, but you didn't hear that today. You might have expected that the defendant went through a red light or a stop sign, but you didn't hear that today. In fact, you heard the officer say the complete opposite. You might have expected that when the officer put on his lights to pull over Mr. Pringle, that it would have taken him a great amount of time to pull over. But you didn't hear that today. You heard that he pulled over immediately, as he was supposed to do, as was lawful. Now, you also might have expected when the officer asked Mr. Pringle to do the field sobriety test, that he wouldn't have asked Mr. Pringle to do tests that involved balance for a man that had back problems, for a man that told the officer that he had a back injury, that he had just been to the doctor recently, that just told the officer about the name of his doctor and what procedure he had. But what did you hear? That the officer asked him to do a number of tests that involved balance, that involved putting his feet together, which were difficult, that involved walking in a straight line, which was difficult considering the fact that Mr. Pringle told you that he had just had a back injury, that he had back problems. Now, you also might have expected that the officer would have demonstrated fully the test that he wanted Mr. Pringle to do. And you've heard today that the officer said Mr. Pringle, when he did the nose touch test, wouldn't close his eyes. But you also heard the officer explain to you that when he showed Mr. Pringle how to do the touch your nose test, the officer didn't close his eyes either. Now, you've also might have expected when the state told you that this was a case about a DUI where they had to prove that his blood alcohol level was above a .08, that the state would show you something with the defendant's blood. But the state gave you a breathalyzer test. And what did you hear today about that breathalyzer test? The experts that Mr. Henniger told you about told you that that test, when perfect, when everything goes right, has a 10% margin of error. It can read 10% higher or 10% lower. And the two tests that the state gave you, if everything was perfect on the .089 test.
Objection. That is an inaccurate reading of the law with of the actual science with the intoxilizer.
I'll allow you to respond to that in your rebuttal.
Mr. Henniger told you that you heard today that the reading of the test was a .089. But you heard today from the expert that it was a 10% margin of error on that. So it could be 10% higher or 10% lower. 10% lower is .079, below the .08 that the state has to prove. But you heard that that's just when everything is perfect. You might have also expected that on a case where everything relies upon this intoxilizer test, that everything relies on whether or not it's calibrated properly, that the state might have brought for you to hear and for me to cross-examine the person who actually calibrated that test. But you didn't see that today. The person responsible for calibrating that test never sat on that stand and told you that he calibrated it. Now, you had someone say the last time it was calibrated, but that person that sat on the stand didn't tell you that he did it himself. He couldn't tell you that he was sure it was done correctly because he didn't do it himself. Now, ladies and gentlemen, as I said, this case is about unmet expectations, and the state has the burden of proof. And their burden of proof is beyond a reasonable doubt. And that's beyond a reasonable doubt is the highest burden of proof in our justice system. Now that's above with the burden that's necessary in a civil suit when someone or some company can be sued for millions of dollars. All that's necessary in those cases is a preponderance of the evidence, or more likely than not. Beyond a reasonable doubt is higher than the clear and convincing evidence standard that's necessary to take away someone's children. To take away the children from a mother or a father, that's more 75% convinced. But no, in this case, it's the obligation of the state, of Mr. Henniger, to show you beyond a reasonable doubt. You must be firmly convinced of the guilt of my client. And you have to ask yourself when you go back to deliberate, are you firmly convinced? Was the state able to show you all of the elements? Was the state able to show you that even when this 10% margin of error takes it so low, and even though they weren't able to give you the person who calibrated this machine, and even though when my client was taking these tests that relied on balance, he had back injuries and he told the officer of that, when you think about those in the deliberation room, you have to ask yourself, are you firmly convinced? Or do you have unmet expectations? And after you ask yourself that question, I think that you'll come back with the verdict, not guilty.